everybody, welcome back to the channel. I appreciate your time. Thank you for watching. It's Guns and Gadgets, the premier source for Second Amendment news. If you like Second Amendment news, including what I'm about to give you today, hit the subscribe button down below, like the video, share the video so other people see it. Let's get into it. Gun Owners of America today dropped their lawsuit against the ATF and the Department of Justice related to the pistol brace final rule. And joining Gun Owners of America is the Gun Owners Foundation and an individual / FFL named Brady Brown. And the great state of Texas is joining GOA in fighting against the ATF. This is a 127 or 130 page document. I just read a majority of it and skimmed through the last couple parts that I'm going to go back and go after in depth. But I love what I've seen and read thus far. GOA is bobbing and weaving, sticking and moving, and they're destroying the ATF in this rule. My hat's off to the GOA attorneys I've talked to throughout this process. Talked to them today. Guys, you have killed it. This case here you can see is page 1. It has been filed in the Southern District of Texas in the Victoria Division. And this is how it starts out. Now come plaintiffs, by and through counsel, and for their complaint state as follows. Plaintiffs bring this action seeking a preliminary injunction to preserve the status quo, followed by a declaratory judgment and permanent injunctive relief restraining the defendants from enforcing various parts of the final rule issued by the Bureau of Alcohol, Tobacco, Firearms, and Explosives of the United States Department of Justice on January 3/1 of 2023, entitled Factoring Criteria for Firearms with Attached Stabilizing Braces, also known as the Final Rule, or FR. Alternatively, plaintiffs seek declaratory and injunctive relief that the National Firearms Act of 1934, as amended, NFA, is unconstitutional as applied to short-barreled rifles. As grounds, therefore, plaintiffs allege the following. Now, I'm not going to go into huge detail in this lawsuit. I'm going to show you a couple things that I think are phenomenal. And let me know what you think down below. Like this paragraph here. GOA says, for example, one such individual, which the final rule will affect and harm irreparably, is an honorably discharged former paratrooper with the 82nd Airborne Division of the United States Army who has a 100% disability rating from the VA, the result of a parachute accident years ago that has caused lifelong strength and mobility challenges. Use of a stabilizing brace is therefore necessary for this person to ergonomically, safely, and accurately shoot an AR-15 style pistol. Likewise, GOA and GOF have heard from persons who own pistols with stabilizing braces and who reside in the states where short barrel rifles are illegal to possess, even if registered with ATF. Such persons have no choice but to surrender, destroy, or modify their firearms into totally different configurations in order to avoid felony prosecution by defendants. Other GOA and GOF members and supporters live in states where possession of a short barrel rifle is unlawful unless properly registered with ATF. As ATF now claims that millions of firearms were not properly registered, this creates potential state criminal liability for such gun owners. As discussed below, registration with the ATF is impossible for these people as they will be providing evidence of not only federal but also state crimes to both federal and state officials. Although the final rule claims that ATF will exercise its enforcement discretion under federal law, nothing in the federal rule binds state officials with respect to past violations of state law. This is a big part. I talked to Rob Olson about this today, and this is some great stuff right here. Also among GOA's members and supporters are current and former U.S. military service members. These service members face an independent risk of prosecution by court-martial for violations of the NFA under the Uniform Code of Military Justice, Article 134. Indeed, GOA has heard from at least one member or supporter who is a current member of the armed forces who lawfully possesses a pistol with a stabilizing brace and who is subject to the jurisdiction of the Department of Defense. For this person and others in similar situations, Defendant Department of Justice's promise to exercise its enforcement discretion is of little comfort. With respect to the Department of Defense, prosecution under the UCMJ's Article 134 for owning a lawful item that ATF now has capriciously classified as a felony crime. In other words, there are a ton of people who, now that the ATF has changed its mind after a decade, they have made all of these people subject to criminal prosecution, whether it's federal, state, local, or even with the military itself, for court-martial. And you can't deny it. No matter what the ATF says verbally, nothing in the rule, if you read it, every single word of it, nothing in the rule says that they can't do it. And law enforcement of all levels, even though they do have the opportunity to exercise discretion, discretion can be revoked at any time. It's not something, once you get it, you keep it forever. At any time, they can revoke discretion. Like I said, this lawsuit is thorough. I mean, very thorough. Goes into, you name it, how the $200 tax is unconstitutional, how SBRs, as ATF is now saying that these pistols are SBRs, they're in common use and they're not any more dangerous than anything else, thus shouldn't be under the NFA at all. How they also GOA did all of the ATF's prior letters that had allowed people to purchase these, knowing or based off of those letters saying that it was okay, and even the police officer's inquiry to the ATF, in which the ATF said, yeah, if somebody shoulders a pistol-braced AR, that's not a problem. It doesn't make it an SBR, no problems. Yet here we are now talking about the ATF changing its mind and then making everybody an unlicensed possessor of a short-barreled rifle. It's extremely well written. Without going crazy in depth on the lawsuit, let's go into what GOA is alleging and what their courses of action are. The first cause of action says that the final rule is a violation of the Administrative Procedures Act because it was issued without observance of procedure required by law. And this has to do with them redefining rifle. The second cause of action is a violation of the APA because it's arbitrary, capricious abuse of discretion not in accordance with law. The third cause of action, a violation of the APA because it was issued in excess of statutory jurisdiction or authority, meaning the ATF doesn't have the power to do what it's doing. Fourth cause of action, in violation of the APA, it's contrary to constitutional rights, power, privilege, or immunity. And you'll see more about that here. The fifth cause of action in violation of the APA is its unlawful effective date, meaning it's a major rule, it affects millions of people, and it went into effect immediately. The sixth cause of action is it violates the Second Amendment right to keep and bear arms. Simply put, it's not in the text of the Second Amendment, nor is there any history or tradition of any firearms regulation that the ATF has been doing or is looking to do, as in this final rule. Seventh cause of action, it's a Fifth Amendment violation relative to self-incrimination. You have to provide all of your information to not only the feds, but also your local law enforcement by filling out your Form 1 in the CLEO, the Chief Law Enforcement Officer section, and that can and will affect you in many states. More on that right here. There are 6 states plus Washington, D.C., where registration is impossible. Of course, 6 states, including California, Hawaii, Maryland, New Jersey, New York, Rhode Island, plus the District of Columbia, independently prohibit SBRs, meaning that a person cannot register an SBR with ATF without providing evidence of a state crime. Meaning, if they can't have a braced pistol, they are forbidden legally by law from having a registered SBR. On top of that, there are 24 states where registration will provide evidence of state crimes because the ATF is saying you are now unlawfully possessing these short barrel rifles, and they're going to exercise their enforcement discretion, but your local or state authorities aren't bound by what the ATF decides to do with their discretion. The 8th cause of action is a Fifth Amendment violation, void for vagueness, because it is unconstitutionally vague. Just one consideration of vagueness is the surface area suitable for shouldering. There's no hard definition. ATF's all over the place. They say verbally in a training that I was in with FFLs that if you remove the pistol brace, then because a buffer tube is required for order of operations, then that won't be measured or used against you. But there's nothing in the rule that says that they can't use that against you. And that's how the federal laws work, guys and gals. If they don't specifically say they can't do it, then they can do it. And then there's, of course, the vagueness around length of pull and all that other craziness. The 9th cause of action related to the Constitution, Article 1, Section 8, it's an invalid exercise of taxing power. And of course, we're talking about the $200 in the NFA. The 10th cause of action, again, the Constitution, Article 1, Section 9, prohibited unapportioned direct tax, again, to the $200 of the NFA. 11th cause of action, Constitutional Article 1, Sections 1 and 7, separation of powers. meaning ATF is not Congress, only Congress can do this, and the final rule violates these provisions, usurping legislative powers. Now, what is GOA, GOF, Mr. Brown, and the state of Texas looking for? Here we go. Wherefore, plaintiffs respectfully request that the court, 1, declare that the final rule violates the Administrative Procedure Act as it is unlawful and an ultra-virus agency action, meaning they don't have the power to do it, ATF. 2, declare that the final rule violates the Administrative Procedure Act as it is not in accordance with law. 3, declare that the final rule violates the Administrative Procedure Act as it is arbitrary and capricious. 4, declare that the final rule violates the Administrative Procedure Act as it is not the logical outgrowth of the NPRM, that's the Notice of Proposed Rulemaking, and does not abide by the requirements of the Act. 5, declare that the final rule violates the Administrative Procedure Act insofar as it is contrary to constitutional right, power, privilege, or immunity. 6, declare that the final rule violates the right to keep and bear arms protected by the Second Amendment. 7, declare the final rule violates the Fifth Amendment's privilege against self-incrimination. 8, declare that the final rule violates the Fifth Amendment's due process clause by being void for vagueness. 9, declare that the final rule is an invalid use of the constitutional taxing power. 10, declare that the final rule violates the separation of powers doctrine embodied in the United States Constitution. 11, declare if the final rule is found to validly apply to the weapons at issue in this case, the National Firearms Act is unconstitutional insofar as it applies to the manufacture, possession, transfer, or registration of short-barrel rifles. 12, declare that defendant ATF's chief law enforcement officer notification requirement contained in 27 CFR 479.62 Charlie is entirely without statutory authority, in violation of constitutional rights, and therefore is both unlawful and unconstitutional. 13, issue an injunction prohibiting defendants and anyone acting in concert with them from enforcing the final rule or from taking any action inconsistent with the rescission of the final rule. 14, grant plaintiffs an award of attorney's fees and other litigation costs reasonably incurred in this action. And 15, grant plaintiffs such other relief as the court deems just and proper and as justice so requires. There it is, guys and gals, a extremely thorough lawsuit that was filed today in federal court by GOA, GOF, State of Texas, and Mr. Brady Brown. And I want to take this opportunity to thank my friends at GOA. The attorneys, Stephen Stambulia, Rob Olson, also Attorney General for Texas, Ken Paxton, also the governor for probably giving the okay for this to go, Greg Abbott. A lot of good stuff going on here, guys and gals. This is the 5th lawsuit against this final rule, and there's one more coming as well. Let me know what you think down below. I appreciate all of your time, and I would really hope you would consider liking the video, sharing the video so more people see this, and subscribing to the channel so that it actually gets out here in YouTube land. Thank you so much for your time. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. That's what it's for. That's why we have it, and it's not going anywhere, nor should it be affected by A, a piece of plastic, or B, a piece of plastic with rubber flaps and a little Velcro strap. Doesn't make sense, yet that's what the ATF is trying to pin their unconstitutional restrictions on. Yeah, I'll see you all in the next one. Take care.